Hello everyone, welcome to LexTalk, World's talk show presented by Click of Creators. Today we have Mr. Srijan Sinha with us. Srijan is an advocate on record before the Supreme Court of India and holds an LLM in technology law from Berkeley Law. He is the partner at Edictum Law Company, which is based out of New Delhi. And there are a lot of things that he's into, but majorly his area of expertise includes insolvency, arbitration, constitution, and competition law. We actually have a lot to discuss about Srijan, what sort of drove him to become a lawyer, and some of the typical questions about his legal cases. But without before we do that, let's welcome him to the show. So, hi Srijan, welcome to the show. How are you doing?
Hi, Sagar. Thank you. Thank you for having me. It's a pleasure.
It's all us. Thank you very much for getting some time finally out of your busy schedule for this session today.
No, it's
So
yeah,
as I said, I tried my level best to cover things about you, and there have been so many recent updates in your journey. So
right,
I just wanted to understand if you can sort of give a small introduction about yourself so that we can get started.
right. So, Sagar, as any other student of the law, we all had to, have a starting point. There had to be a motivation to agree to, get into this field. So for me, the motivation has been twofold. One has been my entire upbringing because I'm a second generation lawyer and I saw my father and my elder brother as well practicing, before me when I was in school and I was in college. So I saw a lifestyle which really appealed to me, A. And B, there was a lot of discussion of the work that used to happen in courts within the four corners of our house. So even as we grew, we were, sort of acquainted to or exposed to the practice of the law. Why does a lawyer say something in court, and what is the impact of that before the judges? And when the judges do decide on that statement by the lawyer, what impact does it have on the citizen? So, from that perspective, it was very fascinating to see how, by applying your mind to a particular set of facts, you can actually get a judgment in favor of your client who can benefit manifold. So that was my first sort of attraction towards the field, as somebody who had no idea about the complexities and the struggles involved. It all seemed very nice and attractive, and that was sort of the start point for me as to why I want to get into the practice of law. Why do I wish to study the law? So that's where it all started. Then, of course, we were the first CLAT batch where we had to give a common law entrance examination. Previously, it was an individual examination per college. So there used to be multiple attempts that people had. And with CLAT, there was only one attempt that one could have at entering into a national law university. Luckily, things worked out, and I was able to secure an admission in a national law university. Uh, and thereafter, the journey has been a different journey where motivations and realities sort of come before you and become clearer. That okay, so there are a lot of things to the law. It is not what we saw, our father and our brother practicing. It's much more than that. There are many areas of law. There are many ways of practice, or rather practicing the law, or helping the common man, or helping corporates, or helping those who have been accused in criminal cases. So in that sense, the second sort of learning came at law school, where we were thrown into the deep end of what the practice involves and what all it may involve. So that's where I got the opportunity to really apply myself and see how do I fit in to the practice, where do I fit in, what do I see. So it was mostly testing the skill set that one has, because frankly in this profession I believe that every time we apply ourselves, we realize and understand more about how we are best suited for a particular practice. Because it's a varied practice, as I've always maintained, that it is not as simple as going to court and opening your mouth and getting a judgment in your favor. It's not as simple as that. There's a lot that goes in the background. There's a lot of research involved. There's a lot of reading involved. There's a lot of original thinking which is involved. So that part of the practice attracted me, where I could prepare the case in my own way and articulate it in my own way, and hopefully impact the mind of the judges in a way that they do agree with the propositions that I lay before them. And thereafter, obviously, fortunately, they may decide in our favor and the client's favor. At the end of the day, there's nothing in the favor of the lawyer. It's always for the client whose mouthpiece is the lawyer. So from that perspective, I was getting clearer as I proceeded year after year in the 5-year course that this is where I'm headed. I'm headed in a direction where I get to argue my own cases, I get to prepare them, and fortunately, that is where I am today as well. Obviously, there has to be a lot of learning. So after law school, I joined one of the top law firms in the country, economic laws practice, their competition team, because that's the subject that I wanted to, start with. That was my area which I really understood. It was a new law at the time. So I worked at the CCI, I worked at economic laws practice, and that was my start point. That it's one thing to say that I want to prepare and argue, but where is the labor? What is the labor? One has to really be very, very clear and focused about that as well. So that was my learning at the first law firm, where from literally printing the paper to getting the petition filed, to from arranging the briefing conferences for the seniors, and all of those nitty gritties which go behind a good performance, really came out in the open for me. At least that was my exposure which I needed at that time, and that's been the journey. That was stint number one, where I could learn something. Then I went for my master's, where I could learn more about the substantive portions of technology laws, because technology was also entering India at that time. From Twitter, Facebook, Google, all of these companies coming into India and having their tiffs and understanding issues with the government policies and laws. It felt like the right time to go there and understand how a developed jurisdiction deals with such issues, so that we can always come back and impart that and utilize that. So I was able to gain a lot from that technical learning also of the law. And after that, I joined an advocate on record. I practiced in the Supreme Court, High Court. Then again, I joined Khaitan and Company, again their litigation team, to have a more wide understanding of the general practice of litigation. Rather than being specific in competition law, I had to foray out of one aspect of the law and get into other aspects such as arbitration, insolvency, and so forth. So that's sort of been the learning curve so far, where I have, till I was at Khaitan, that there's a lot that goes in the background. And unless we are not, able to capture and learn that really well, it will always be difficult to go and argue and appear before court. So I feel that's been my sort of, focus area in the practice of the law. Obviously, in this journey, I have forayed into other, practices as well, which may be corporate, which may be called transactional work. That has always been there, but as they all say, there's always going to be one pet area, or a more focused area in which one would choose as a profession. So that's been the journey, that's been the orientation, that's been the background. And from there, I finally decided that I've had sufficient experience with big law firms to understand the nitty-gritties which go behind a delivery or a performance in court. And that's when I decided to start my own independent practice. This is in 2019 early. So for the past 3.5 years, uh, I have been litigating in all courts in the country, be it the High Court, be it the tribunals, be it the Supreme Court. And it's been a great journey. It's been a very fulfilling, challenging journey with a lot of struggles involved, with a lot of learning involved. So that's when I finally decided that it's I've reached a stage where I need to start a law firm of my own. And I have two partners, and we've just started a litigation plus transactional work oriented law firm. So that's been the journey so far. That's how I've been oriented to this point.
You've covered a lot of things. I had so many questions around the things that you uh, were supposed to. I mean, I was supposed to ask you, but you sort of covered it. So thank you very much for making it easy for me and my viewers. I didn't have to always come in and ask you the same thing. But
Right.
you mentioned about you were not really aware of what's the complexity and how does it seems. You see, uh, everything looks beautiful, from far. Even the forest looks, Amazon forest looks so beautiful, but it's one of the most deadliest forests around the globe. So the reason why I've mentioned this is because now I want to understand if you can sort of help us in understanding a very recent or any complex legal issue you worked upon, and what was the complexity, if you can tell us in more of a simplified manner, and
Sure.
how you really approach.
Sure. So, Sagar, I'll give you one example. Now, this example is being chosen because it was a highly, one of those publicized cases where, it was published in all the newspapers and it drew a lot of attention. It sort of set the stone for all times to come with respect to the topic. So, I'll tell you the complexity and what was the issue involved. Uh, Let me put it in a simpler manner. There were two orders which were passed, one by a trial authority and the second by the appellate authority. Now, both these orders are against me and my clients. And the only option left now is to file a final appeal in the Supreme Court. And this is a matter pertaining to insolvency and bankruptcy court, where once I file a petition, it may be admitted or rejected. That's the language in the code, to put it simply. Therefore, the tribunal cannot act outside the code and give an option number three which does not exist. Was my entire case. So I lost before the trial court. I lost before the appellate court, which is NCLAT, NCLT, NCLAT. And then my final, appeal that I could have preferred was before the Supreme Court. So here I have two orders which are against me, where I have lost, where I could not convince the judges with my proposition of the law or understanding of the law. So therefore, I still believed that there is a case to be made here, and there is something which needs to be brought out to the notice of the appellate court or the apex court in this case. So that's the final court of appeal. So we, after much debate and much thinking internally, we decided that we have to levy a challenge and we have to go to the top court because it's a new law. IBC is a new law. There is always some seminal judgment which keeps coming. I mean, it's a 2016 code. So you can imagine it's just been there for 6 to 8 years, whereas we have laws which are 100 years old. So it will be a teething issue, as we call it. So we decided that this needs to be decided one way or the other. Let it be decided against me or for me, but in the interest of justice and for clarity purposes, this point of law must be decided one way or the other. So that's how we decided that we must file an appeal. See, there's always an officer of the court component attached to these things. that we as lawyers are also officers of the court. So we have to assist the court to take the right decisions, right? So there was that angle involved as well, that we must go to the Supreme Court so that the Supreme Court can lay down the right law, whatever that may be. So we, with very little confidence, but with a lot of hope, we filed our final appeal before the Supreme Court. And on the first date itself, we were able to secure what we call a notice being issued, which is basically the case being admitted that, okay, we prima facie think that we need to, decide what this issue is. So therefore, we are issuing notice. We'll see on the next date, after the pleadings are complete, what should be done in the matter. So this took about a year's time before we could have it finally heard. And in December of 2021, this came up for final hearing before Justice D.Y. Chandrachud and Justice Bopanna. They were sitting in a bench together. And this is now listed for final arguments. We have the opposite side, their pleadings, our pleadings, everything before the court. So I argued this matter and again re-emphasized my propositions with more research, more detail, and relied on several case laws which I thought was relevant to make my point. And luckily, I mean, the judges now, that's the new incoming Chief Justice, Justice Chandrachud, at the time agreed with our proposition, found both the orders to be wrong, which have been passed by the trial authority and the appellate authority, and set the law straight. That there are only two options for NCLT: either you admit or you reject. There is no third option which has been given in the code. So therefore, it should not be that they act as courts of equity, that they take a third option or they create a third option. That should not be the case. So that's where we were not only able to have a victory for our clients, but we were also able to ensure that the law is laid down for all such other matters also. Where the trial court or the appellate court may take a view which is, a third view, which is not allowed by the court. So that was a judgment, it got printed everywhere. It was, it was something that I argued. It took good 1.5 hours of arguments in court. And there were certain senior lawyers, because it was all virtual at the time. There were certain other senior lawyers who had locked in that I'm, in good terms with. So they had also sent messages that we heard you and it was a, great argument, and etc. etc. So that was one of those, seminal complex cases, as well as seminal cases in the trajectory of a professional. So from that perspective, this is one case which really, hit the nail on the head. Let me put it this way. It went on all newspapers from Times of India to, all the leading dailies. So that's one issue that I would like to sort of use for that answer.
I mean, that's really wonderful. I was sort of hearing it very, very attentively, because I've never heard of something like this. Generally, the cases are, you see, this also comes under example of value addition. As you said, it's not just, you just didn't get victory for your client, but you also ensure that it's being laid down properly in all sort of degrees for other cases, other relevant cases. So that is very beautiful. And I always generally state, there's a movie that I've seen from Bollywood itself. It says that a legal fraternity, it's not really, it's not a business, but the line said that it's not a business of justice, it's a business of law. So you have to work, keep on working on that. That is really beautiful, Srijan. We will dwell down into this. I mean, I had some layman's question, which I really don't think that I should put it this way, because this has been going really beautiful so far. I just want to have your take, since you are you're a lawyer of my generation, I would say, if I may say so.
Please, yes.
How would you rate the current legal system's right towards encouraging access to justice? And is there a gap? And if there is there a tangible movement in closing the justice? What do you think? Or what's your take on this?
So that's a question which will continue to be relevant for a long period of time, in the sense that there is always a class of the professionals which are trying very hard to bridge those gaps and to allow access to justice, to the common man, as we call it. Because at the end of the day, they are the ones who need more access and more help than the ones who are rather fortunate to afford better legal services. And from that perspective, there's been a considerable change in the attitude of the judges, in the policies which have been adopted by, the central government, the law ministry, so to speak, where fast track courts have been opened. There are lok adalats, there are mediation drives which have now really taken the forefront, where it is always advisable for those who are less fortunate to not get into litigation, but to get into mediation and try and resolve their disputes. So there are now many such mediation centers which have been opened all over the country to allow for those people who are less fortunate to not get into complexities of courts. Let me put it this way: litigation by its very nature is adversarial. In almost all probabilities, it's an adversarial dispute which comes to court, and it is not for everyone to go through with that adversarial process, because it requires both time and money and resources availability, etc., etc. So I do feel that there are gaps. It is not that there is no gap whatsoever. But at the same time, I do see that there are a lot of solutions which are available, but for the right way of communication. I also feel that there are a lot of high level points which exist, but they haven't reached the right ears. So that gap, which is more, I would call it a communication gap rather than a facility gap. Facilities are there, but the existence and the approach to that particular facility, these are communication gaps where somebody has to take that baton to communicate really as to how all can a particular layman uh, access the courts and resolve their disputes. It's as simple as that, but it's as complicated as that as well. At the same time, who is going to be communicating? Where is the communication supposed to land up? What is the portal that needs to be created? So this is where I think a lot of the tech startups, will definitely come into the picture as extremely relevant. They will be able to drive this point home and bridge this gap. It happened in education, where a company like Byju's is able to acquire a physical company like Akash Institute. Why is that happening? It's happening because Byju's is able to communicate better. It is able to reach more homes. So we also need a tech support here, in that sense, where the communication and the correctness of information is provided to the common man on his phone, on the ASCII, like a Google for these things. Uh, so I do think that it'll have to be a collaborative attempt, and the government may come out with a lot of facilities, but for the government to also communicate it, although it is their responsibility, but in our limited understanding, it has been difficult to communicate it as well, in addition. So that's a gap which I hope some startup, some legal tech startup sort of bridges and allows for access, because it's going to be a great initiative in that sense. So yeah, that's what I feel, that facilities exist, but communication is poor.
And that's very beautifully put, because my next question was sort of regarding the in the pandemic, courts, we saw courts begin moving towards more virtual hearings,
Right.
and I guess you sort of answered that as well, because when the
Right.
communication becomes easy, and even for lawyers and it saved their time as well. We have heard asked this question to so many people, and everyone basically said the same answer, that it saved their time. Someone can appear in a court. From Delhi to a case which is running in Kolkata or Mumbai or even in Kashmir or wherever it is happening. So that was a beautiful part of it. You mentioned about legal tech, and we are all entering, rather, I would say we are standing in the era of legal tech now, finally coming to our side of the world. What are the most common tools used by you as a lawyer in order to increase the efficiency, or for anything that from that standpoint?
Right. So, see, nowadays, tech is available for a lot of aspects of, the practice of the law, be it managing your cases. So there is ProVakil and a lot of such apps which exist to manage your cases, where you feed in the data. They will track the listing of the matter. They will track the next date in the matter, where what all pleadings have been filed. If you wish to upload certain documents to that particular case, you can do that as well. So there's a lot of case management support which was earlier, all physically handled. Let me put it this way. Initially it used to be a physical file with physical copies and a physical way to go and check when the matter is listed next. There was no tech support to manage these simple things, and this saves a lot of time and money for any office. So once you have such support, you're able to at least have a broad overview of where which case is headed, when is the case listed, so that you can plan accordingly. That's also very important. Time management is key. So that's one of the new age legal tech apps which have really helped a lot of the practicing professionals, including me. So that's one. Second, in terms of research, we have SCC Online, we have Manupatra, we have a lot of such search portals, which allows us to go through all the cases which exist as on date and search for the right case which may apply to our set of arguments. So that is the second most important, as I would call it, and that has been there for a while. It's not something new. It's with the SCC Online and all of these apps for searching cases have been there for quite some time, and they will continue to be a strong factor in anyone's profession. Number two, and lastly, I think just having the screen becoming your source of representation before court as well. Now that we have our meetings with clients through the virtual setting, that we argue cases virtually, which are so important, etc. That is definitely becoming the third source of legal tech, which was always relevant, but for it only came into existence through Corona. So it sort of forced every individual to adopt and adapt both the virtual scheme of things, where you can send your physical files virtually, where you can appear virtually, where you can screen share and show documents to the court virtually. So this really streamlined. Plus now there's e-filing in the Supreme Court and in High Court. So you can file your cases at midnight. That never used to happen before, because the registry was shut down at 5 and 6. And after that you have to then go at 10 a.m. or 9 a.m. next day. So that's another, all of these things together, they're sort of coming together. Let me put it this way. They're all coming together in a nice way to uplift and change the approach to the same things which existed and which will continue to exist. The manner in which we represent our clients is now becoming easier, simpler, more accessible. This allows for anybody sitting anywhere in the world to enter appearance in court. Many a times it used to be that we would walk into court and say that the client is out of the country, therefore he cannot appear or she cannot appear. But now that has changed. They will log in online, they will show their presence to court, and they will sign, digitally, and make that exit. So definitely, the virtual aspect of things uh, is extremely useful. Right.
That's really wonderful. The reason why I asked you is because you are well aware of the legal technology that is coming on board,
Right.
and there are a lot of things that can be used, especially for the young lawyers who are entering the practice now.
Right.
Um, so far, this has been a great session, Srijan. My last question to you would be, if you can guide us, because for our viewers, as I said, very recently, Srijan started his own law firm, Edictum Law and Company. So I also wanted to understand the practice areas of Edictum Law and Company, and where can uh, our viewers find you really and your law firm.
Right. So we are currently handling corporate commercial litigation, as I put it. It involves clients across the board, be it a financial institution, be it a real estate developer, be it any other such corporate company engaged in corporate work, which either has a litigation requirement where there is an arbitration to be carried out on their behalf, or there's an arbitration initiated against them, or there is an insolvency case initiated against them, or in the sense that there's a criminal action which has been initiated, what we call as a white collar crime. So we are across the board in this particular sector. When it comes to corporate commercial, it includes white collar crimes, it includes insolvency, it includes arbitration, it includes loan oriented, loan default oriented litigation. So that's the space that our law firm is in, and that's the space which we have sort of built, in the years that we've been working. So Edictum Law, in that sense, is mostly focused on providing corporate commercial litigation support across the board, be it before a high court, before the Supreme Court, or before tribunals, or a private tribunal in the case of arbitration, or before any of the enforcement agencies like the Enforcement Directorate, or for that matter the CBI, or any police investigation which may have been initiated. So we provide a full support across all these forums in this particular category of corporate commercial. And
That's
obviously,
really
we're
great.
not limited to that. As I said earlier, if we can provide this support, then the support extends to transactional work as well, where we try and prevent all this. let me put it on. Let me put it that way. So yeah, it's a full service law firm in that sense.
Great. And I guess our viewers can definitely find you on LinkedIn, and you have a website
Right,
for your law firm.
right. We have a website as well. Right. So they can
Brilliant.
always
So
reach out to us.
brilliant. So we will share these details in the description of the session, and our viewers can always find you can always find Srijan to sort of understand more about the legal fraternity. Let me put it that way, and to bombard him with your questions. And I guess he has that helping hand to sort of especially for the
Right.
young practitioners and for the students. So as I
Absolutely.
said, Srijan, so far this has been a lovely session, and I always really wanted to have this session with you. We were waiting for this session since quite long, so I'm really happy
Thanks.
that we got a chance. And we
Thank you.
look forward to
Pleasure
having
was mine.
such great again with you in future on some other training topics in the international legal
Absolutely.
industry. So thank you very much
Absolutely.
for the session today.
Thanks, Sagar. Thank you so much. It's been a pleasure.
It is all mine, Srijan. Thank you very much once again. And for our viewers, if you like this chat with Srijan, I want you to like this video, to share this video, and click on that red button and subscribe to Click Away Creators YouTube channel to appreciate what we do. And you have more coming in from legal industry leaders, or rather, I should say, legal fraternity leaders, just like Mr. Srijan Sinha himself. This was Sagar for LexTalk World signing off.